Good afternoon, and welcome to Law is Stranger Than Fiction. I'm one of your co-hosts, Steven Bergman, a shareholder in the Salt Lake City law firm of Richards, Brant, Miller, Nelson.
And I'm your other co-host, Barry Shull, also a shareholder at the firm of Richards, Brant, Miller, Nelson.
And today's episode takes us back into the realm of employment law. Specifically, in this case, we're talking about a former law school professor who claims that he was retaliated against by the law school, and the way that they retaliated against him was by giving him a raise of $666, and thereby humiliating him by giving him a raise that was the signifier of the mark of the beast in religious circles.
Did he bring litigation over this?
He did. Filed a lawsuit in federal court over it, actually, and made a number of claims, including the retaliation claim for getting a $666 raise.
And what was the outcome at the trial court level?
Not surprisingly, not very good for the law professor. He lost. The district court found that he had not established that he was retaliated against, and he had not established that the raise of $666 was unlawful retaliation.
And was that the end of the matter?
No, he actually appealed the case and took it to the Sixth Circuit Court of Appeals.
So wait a minute. He was arguing that he was retaliated against because he received a raise of $666, and he took this to the Sixth Circuit Court of Appeals.
I don't think he chose the Sixth Circuit. It just happens to be that this case took place in Ohio, and Ohio is part of the Sixth Circuit. But you think if there's any circuit that might be somewhat sympathetic to a claim based on a $666 raise, it might be the Sixth Circuit. So,
okay, and what was his argument on appeal?
Again, he raised the retaliation claim. He had been trying to unionize some of the law professors at the school and claimed that his First Amendment rights were being infringed because they retaliated against him by only giving him this $666 raise.
Now, I understand that originally the raise was slightly more, $727, a figure that, as far as we know, has no religious significance. How did the school arrive at the figure of $666?
Well, when questioned, the dean of the school explained that in that particular year, they had broken the professors at the school into three tiers. And the top tier got a $5,000 raise, the second tier got a $3,000 raise, the third tier split what was left over. And because of the size of the pool and the number of professors who ended up in the third tier, it ended up being $666 when they divided it.
And is that professor still, having lost on appeal, is he still presumably teaching law?
He is not. He actually retired a couple of years prior to this case being decided. And his wife was also a teacher at the school and who had also received a $666 raise, was laid off because the school was actually experiencing declining enrollment.
Okay, now I know you practice employment law. Presumably employers won't see a case involving the mark of the beast. What are some issues they might encounter?
Well, obviously, if you've got an employee who is taking advantage of the First Amendment right, trying to organize, trying to unionize, you can't retaliate against that employee. You have to treat them equally the way you treat all the other employees. And that's what ultimately protected the school in this case, is they could demonstrate that, well, the raise, several anti-union professors also got the same raise because it was decided not by an arbitrary number meant to embarrass the professor, but by simply dividing the raise pool among the number of professors involved. So now if you're an employer and you have an employee that's trying to unionize or trying to engage in other activities that you think might be questionable and you don't know what to do, contact the attorneys at Richards, Brant, Miller, Nelson. We're here to help, and we look forward to doing so. For now, I'm Steven Bergman.
And I'm Barry Shull.
And law is stranger than fiction.